अॼु असां ही लेक्चर कॉन्स्टिट्यूशन ते स्टेज वाइज़ हलंदासीं ऐं कोशिशि कंदासीं त कुझु लेक्चरनि में हिन सॼे जो सॼे हुनखे कवर कयूं कॉन्स्टिट्यूशन जे किताब खे ऐं हिन जी हिकिड़ी बुनियादी अंडरस्टैंडिंग डेवलप कयूं। इन करे अॼु असां कयूं था इंट्रोडक्शन ऐं हिस्ट्रीअ ते, ऐं पोइ सुभाणे खां वठी वरी चैप्टर वाइज़ नेक्स्ट लेक्चर खां वठी वरी चैप्टर वाइज़ हिनखे कंदासीं। सभ खां पहिरियों जेका सुवाल ज़हन में ईंदो आहे त व्हाट इज़ कॉन्स्टिट्यूशन एंड वाई कॉन्स्टिट्यूशन। Constitution is made by in this country by National Assembly and Senate through a two-third majority resolution. Those people in the National Assembly are MNAs. The MNAs are elected by citizens who are eligible and in the voter lists of every elections that we have every 5 years. They make the constitution. So this is actually a principle that the constitution, which is a framework for the citizens, state and other organs to operate and function. It defines rights and liabilities between people and state and its organs to set a minimum standard that we will abide by this. It's, in other words, an agreement between people and state. State makes certain promises. The agreement is made by will of people through their representatives. So that's constitution. In this constitution, we have defined certain fundamental rights. We have specified them. Then we have specified certain policies that a state will follow. We have created basic institutions like finance, like government, army, defense, judiciary, and then there are further laws enacted under the constitution that are subordinate to the constitution. There is a different process for making them provided within this constitution. Those laws will then further make even more functionaries and state institutions and create even more rights to regulate the life of people. So the constitution gives basic principles and understandings for the citizens. Primarily, the most significant for ordinary people are fundamental rights, remedies in case the fundamental rights are being violated by the state, institutions, basic institutions, the government, every provincial government, makers of the law. So this is like three main institutions are provided in the constitution. That is government, then we have assemblies to legislate, the legislature, and then we have the judiciary to decide the cases and disputes with the government, between government and people. So we are all party to the constitution, party to this agreement, basic agreement. In this basic agreement, we have always been told that there is a trichotomy of power that I have learned from my teachers in colleges, and I hope all of you have also known that there is a trichotomy of power. In my view, it is not so. We do not have a trichotomy of power. So our laws are made by, say, let's take an example, National Assembly, for the federal government's sake. National Assembly passes a resolution that passes through the Senate, is assented by the President, becomes a law, becomes an act of the Parliament, Majlis Shura. We say it's a one pillar. Other pillar is the judiciary. The third pillar is the government. But there is, so these three pillars are called trichotomy. But in essence, if we look it properly, that in this agreement, it is not trichotomy, it is bichotomy. How it is bichotomy? Because there are primarily two pillars. National Assembly will enact a law according to this constitution. Then that simple majority which will pass a bill will also be able to appoint head of the state, head of the government, that is the prime minister. So that means creator of the law and creator of the prime minister is the same authority, same body. So saying that the government is a separate pillar from the legislature in these circumstances, in my humble view, is not so. Many of you might not agree with this because we have always been told it's trichotomy, but I don't see it because, see, if I appoint, I make this law with simple majority, and I appoint this person as a prime minister, that means I'm the one pillar. Whatever law the prime minister will want to be passed, we have seen in the history of this country, those laws have been passed. Why they can pass it? Because they always remain in majority in the National Assembly. So it's essentially the government or the parliament, and another leg is the judiciary. These constitutional frameworks are internationally evolved. So whatever agreement we have between the people, between us, this shows a lack of trust within the subjects, within the members, within the parties in the agreement. For example, if I give 1 lakh rupee or say 10 rupee to my brother or to my father, I will not ask him to bring a stamp paper, let's write an agreement, and we both sign it, the witnesses will sign it, and then I give you this 10 rupees. We don't do that in our daily life. Why we don't do this? Because we trust the other party. We don't need an agreement if we have a trust. But if I give the money to somebody, a stranger that I don't trust, then I will ask him to execute an agreement or at least give me receipt that I have given him the money. So in tomorrow, if he turns and says that I'm not giving you back, I can take this receipt and try that receipt as evidence to prove that I've given him money for recovering it. So this very need of having an agreement is actually based on the lack of trust between the parties. More detailed the agreement, lesser the trust. I'm giving you 10 rupees. You will take these 10 rupees on Friday to store A, and there is a cashier on the left side of the door. You will give him at 10:30 p.m., and in exchange he will give you a, say, chocolate, and return you 5 rupees. You will bring that at so and so time. The purpose of saying this is that more you detail it, more you specify every term, how it will be treated, how the relationship will be treated, it shows that we don't trust each other enough. So we want to have every step properly defined in the agreement. And to define every step in the agreement is not trusting the other party enough that he will do it right. So thicker the constitution, heavier the code, lesser the trust and understanding between a state and its people and within the people. This is the reason those countries where there is not too much of a trust deficit, we have very thin constitutions. Like, take an example of America. It's a small constitution, not as detailed as we have a whole thick book. Even every small detail we have written in it, try to cover up everything. So we know that somebody there, people will try to find out a way to get away with it. Same is the case with the certain other countries who also have such detailed constitution. Who will be the judge? How he will be? What will be his age? What will be his qualification? Which domicile he will have? Likewise, who will be the prime minister? Every detail about all the posts we have tried to provide in the constitution, try to regulate it in very detailed manner. Purpose of this discussion is to understand that this actually shows that people in Pakistan or people, say, in India or other countries, they have a lot of trust problems for each other. That's why we have very detailed constitution, basic framework, basic agreement. This is basic agreement, master agreement between people. We should, ideally, this, any good society should try to minimize it. We should improve our conduct in a manner that we eventually keep amending this to reduce the burden, reduce this lack of trust. This is why we have this need of this lack of trust, is because we have a very different demographic structure, and all of these people from different backgrounds have been brought up in a manner that we have this deficit. This would be a very, you can say, a social study to understand it in more detail, how to, why we have this trust problems, how we can overcome. That's a separate subject, but for now we just have to understand that this is a basic agreement between people and the country and the state and its organs. Basic principles provided how to work, but these basic principles are also very detailed in our country, which is not ideal, but we have it. This means we need to improve it more, and it needs further refinement. There are now, if we go on the preamble, because it's first part of this constitution, this state has a religion, that is Islam, under this constitution. So our land is Muslim land. It's, this country came into existence on the slogan of La ilaha illallah. So we have incorporated that within the constitution. We have also recognized in the constitution that sovereignty belongs to Almighty Allah. It is the chief executive of the country, a president of the country, whoever you call it, is not sovereign. He is subservient to the will of God. It is exercised and expressed through people in the legislature assemblies that we have. the state and other organs in this country will exercise their powers through people, and those view of the people to exercise in a manner will come through elections in the form of MNAs. This is the basic manner of any democratic society. We will provide freedom, equality, tolerance, social justice as provided in Islam. So we have tried to incorporate Islamic way of life in the constitution as much as there is space available in the life. Now, if you try to understand the fundamental right, freedom, equality, tolerance, these are all basic human civilized manners of life. So we have right to speak, we have a mouth, we have a tongue, we have vocals, we speak, we cry, we have a right to speak. It's granted to us by birth. So we have to understand what is the importance of fundamental rights that we have stated in the Constitution. Fundamental rights, one judge said in a discussion that fundamental rights are not fundamental because they are in the Constitution. Fundamental rights are so fundamental that they are in Constitution. और ये चवण जो मक़सदु इहो हुयो आहे त जेकॾहिं कॉन्स्टिट्यूशन में फंडामेंटल राइट जेके ॾिनल आहिनि, मिसाल राइट टू लाइफ न हुजे लिखियल, त तव्हांखे जंहिंखे मर्ज़ी पए तव्हांखे मारे छॾींदो। फर्ज़ कयो, जस्ट फॉर सेक ऑफ अंडरस्टैंडिंग, if we say that this article 9 about right to life does not exist as a hypothetical understanding, just understand this, is not in our constitution, will everybody be authorized to kill whoever he likes because nobody has right to life? No, that will not be so. This is this constitution or fundamental rights or basic understandings are actually a structure of a civilized society, principles of civilized society that we get. Historically, to run the governments in this modern era of democracy and industrialization, developed, trying to develop the way of life, making it easier and easier and more convenient to live. We have made these laws. So when Pakistan was separated from and came into existence in 1947, we inherited Government of India Act 1935 as a provisional constitution. Then we got first constitution in 1956, which declared Pakistan as an Islamic Republic, because in 1947 it was not declared Islamic Republic. Government of India Act had nothing like this in the statute. Though we came into existence on the slogan of La ilaha illallah, then that was abrogated in 1958. The constitution, the promises made within the constitution were not good enough to, or the people, parties in the agreement were not good enough, so they violated it. And that violation went into the abrogation of the agreement. Litigation went on. We can go in the litigation, say the Doso case was filed in 1958 when this constitution was abrogated. Five judges of the Supreme Court, which was gave a judgment, the Chief Justice of the time, Mr. Mohammad Munir, wrote the judgment ruling that the martial law imposed by Iskandar Mirza validating abrogation of 1956 constitution was correct because it was a need of time. They brought a doctrine called doctrine of necessity and Kelson's theory. Now this there was or there is even today there is no space in any of the provision in the constitution which says that you can abrogate this constitution whenever you want. When the circumstances so warrant, you will abrogate the constitution. Some provisions or some parts of it may be suspended in certain situations. But then this theory of necessity brought a first, in my view, a disaster in this legislative and political disaster in the country. Mr. Ayub Khan was appointed Chief Martial Law Administrator. He was given powers to issue martial law regulations. They were as good as law by the assemblies. Muhammad Munir was born in Amritsar in the British India times, and he studied in the Government University College, Lahore. Then he became Chief Justice and gave this judgment. Then there was a second constitution in 1962. Ayub Khan centralized authority and was again suspended in 1969. Then an interim constitution came in 1972. Then this current constitution was enacted on 10th April 1973 by weeks. In 1977, another case of Begum Nusrat Ali Bhutto came. This was a bench of 9 judges who unanimously decided, and the judgment was authored by Chief Justice Anwarul Haq, that in the military takeover by General Zia in 1977, 5th July 1977, and detention of political leaders under martial law order was valid. Again, the theory was the government and the situation issues are so serious that we need drastic measures, and so now this is validated, and then regime's actions were subject to continuing judicial review, and efforts will be made to restore the constitutional democracy. So Sheikh Anwarul Haq was born in Jalandhar, British India, and he studied in Punjab University. He was also a Chief Justice. Then we had Zulfikar Ali Bhutto execution case. We had Benazir conviction case. We had Nawaz Sharif case. And now we have this famous Imran Khan case. And before that, we had these three different cases about the floor crossing. So these are all our judicial decisions which are relevant to understand the trust we have between members of this basic agreement. We keep on violating it, and then our courts have tried to justify those violations. They may be right, they may be wrong. That's an individual opinion. We all have to study it and to understand whether uh, such drastic measures should be allowed as have been allowed. It's academic discussion. Then we have kept on amending this constitution. Now we have reached 27th amendment. This also shows that from the agreement we are not happy with it. जेकॾहिं तव्हां ॿिनि धुरियुनि में पंज धुरियूं पाण में एग्रीमेंट कयो हुन में 27 तरमीमा कयो एग्रीमेंट में, माना त तव्हांखे सम्झ में नथो अचे त एग्रीमेंट करणी कहिड़ी आहे. So this frequency of amendments also shows that parties are not have not reached a proper agreement. जेतिरो जल्दी जल्दी असां हिन में अमेंडमेंट्स कयूं था हिन मां नज़र इहो थो अचे त जेके बि हिन जा पार्टियूं आहिनि एग्रीमेंट में, जीअं मिसाल असां 10 माण्हू गॾिजी हिकिड़ी कंहिं एग्रीमेंट कयूं कंहिं बि कम जे लाइ, ऐं पोइ असां हुनखे फ्रीक्वेंटली हुन में अमेंडमेंट्स कयूं ऐं हिक ॿिए ते क्वेश्चन रेज़ कंदा रहूं त हीअ शिक सही न आहे, हीअ शिक सही न आहे, हे मसइलो अथसि, हे मसइलो अथसि. इन जो सम्झण वारी ॻाल्हि सिर्फ़ु इहा आहे जो डिस्कशन में त हिन जो मक़सदु छा आहे. मक़सदु अपेरेंटली इहो आहे त कि जेका पार्टीज़ एग्रीमेंट लिखनि थियूं इहे पार्टीज़ एक्चुअली कंहिं प्रॉपर एग्रीमेंट ताईं पहुतियूं ई कोन, अंडरस्टैंडिंग ताईं पहुतियूं ई कोन उन्हनि खे. उन असां प्रॉपरली हिक ॿिए सां के बुनियादी एग्रीमेंट जा जेके शिका आहिनि शर्त आहिनि उहे सम्झा न आहिनि या हिक ॿिए खे प्रॉपर कन्वे न कया आहिनि ऐं असां एग्रीमेंट ठाहे छॾी आहे. पोइ असां हिक ॿिए खे वरी कायल था कयूं यार हाणे भला हीअ अमेंडमेंट कयूं, हीअ अमेंडमेंट कयूं. तव्हां अगरि ॾिसंदव त in US we don't have so many amendments in the constitution, or other countries which have developed, like in some countries we don't even have a proper constitution. For sake we can take a name, uh, United Kingdom. They are working, they are functioning, they have all the same systems that we have now. In fact we inherited their governance uh, systems when we received independence. So we inherited their systems. They don't have a proper written constitution. They don't keep on amending like there's nothing to amend. In US we don't amend. So you amend the agreement as many times as you fail to properly convey your understanding between the parties. We have to find out this common ground between us to understand how we will reach a proper constitution, proper amendment. So what is also an important here is that we have this basic understanding amongst us. We should try to abide by it. More you follow it, easier it will be. But see, if we are very young in the realm of nations, जेके क़ौमां हूंदियूं आहिनि उहे ॾहाकनि में न ठहंदियूं आहिनि. असांजी हिकिड़ी सेंचुरी बि उमिरि न आहे, हिन क़ौम जी हिकिड़ो 100 साल बि उमिरि न आहे. ये जिन क़ौमनि जा हाणे मां नाला खणी मिसाल ॾिना अमेरिका जा या पंहिंजो बर्तानिया जा, त इहे ॿटनि सदनि खां हिते मौजूदु आहिनि. शायदि इहो हिकिड़ो पार्टीज़ खे मैच्योर थियण जो टाइम खपे. हिन में जेके बि रिलेवेंट इदारा या शहरी माण्हू हिन जा एग्रीमेंट जो हिसो आहिनि, कॉन्स्टिट्यूशन जो हिसो आहिनि, दे नीड टाइम टू मैच्योर देयर कंडक्ट, देयर अंडरस्टैंडिंग. हिन वक़्तु आहे टग ऑफ वॉर. We try to encroach on the authority and resources of other party. Let's say judges try to encroach on the authority of the government. Government tries to reduce and encroach in the authority of judicial functions, try to interfere in the judicial functions. Judges try to interfere in the government functions. Likewise, other institutions also try to grab as much power as they want. This is why, this is because we are so child, so young. लाइक जॾहिं नंढा ॿार रांदि खेॾंदा आहिनि त पोइ उहे ज़रूरी न आहे त उहो क्रिकेट वारो सॼो प्रोसेस फॉलो करे खेॾनि उहे हिकिड़ो बॉल वाधारो बि खेॾी वेंदा कंहिं महिल नो बॉल करे वेंदा असां अञा उन स्टेज ते वञा एतिरा मेच्योर न आहियूं saying that we are not a good nation is the purpose is not saying that we are not a good nation. The purpose is that we are young, we need more understanding, we need more time to grow. When we'll grow better. We have better times to grow now. I think we should conclude today's discussion here because we have reached to the part 1 that we will do in the next lecture. If we have any questions on the what is constitution, why constitution, we can have them. Anybody wants to discuss it.